side, it's not hourly billing, so we'll be short.
Yeah.
I love your Empire State Building behind you, Jeremy. I'm going to do.
Greetings to everyone present. My name is Ankit Malhotra. I am the co-founder and president of the Jindal Society of International Law. Today, to speak about a topic of extreme relevance, not only for citizens, but also those whose lives are at stake at all moments and costs, is the paramount concern of the jurisprudence of the protection of children and their rights. But before I introduce our speakers for this discussion, I would like to spend a moment to talk about the Jindal Society of International Law, which was created on the 18th day of November 2020 and was launched by the Herbert and Rose Rubin Professor of International Law, Professor Jose Enrique Alvarez of New York University, along with our Vice Chancellor, Professor Dr. Siraj Kumar, the Faculty Coordinator and President of the Society, Professor Dr. Weston Paskey, and a dear friend of the society and also of the university, Professor Dr. Mohan Kumar. The purpose of the society is to encourage student interaction with the subject matter of international law through its various initiatives. Rather than being primarily research-driven, we intend to offer a host of experiences that contribute towards skill building, increasing the knowledge database available to students all across the globe. The society is an attempt to bridge the lacuna by streamlining resources and inculcating an international interest of the resources available to us in international law. The spring lecture series of 2022, entitled The Colloquium on Challenges to Global Governance and Humanities in the 21st Century, offers a compendium of scholarship from the academy and professional experience from the bar. Over the past year, the society has hosted over 100 speakers from international law firms, the International Law Commission, World Bank, Hague Academy of International Law, the Institut de Droit International, and also the United Nations. Through our previous series, we endeavored to study the different contours of international law through the speakers who covered and addressed various aspects of international law. Given the vast ecosystem of international law and the engagement in it, the society aimed to study the fragmentation and fertilization of these various disciplines. Over the years, the society has become a quorum of thought-provoking discussions due to its engagements aimed at exploring this ecosystem of international law. However, with the spring lecture series, it is important to understand the challenges from broader, different, and most importantly, differing vantage points. Acknowledging international law as a creation of states, it is important to understand and appreciate the social sciences and humanities that have played a key role in shaping the law. Thus, a broader study becomes critical and also crucial. Through its series, it is also hoped that one will develop a deeper understanding of international law. And to speak about an important issue of international law is the interparental child removal and a discussion from global experts on this very topic. We have following speakers and I introduce them in the order in which they will speak. We first have amongst us Professor Maya Croft, who is an international lawyer based in The Hague and is the convener of the Climate Governance Commission that seeks to propose high-impact global governance innovations adequate to meet the challenges of climate change. As a principal legal officer, she is aimed to work on the development and administration of multilateral treaties, as well as at international criminal tribunals, and a start at the Hague Academy of International Law. We then have amongst us Professor Marilyn Freeman, who is the co-director of the International Center for Family Law, Policy and Practice. She's also the principal research fellow at the Westminster Law School, London, and chairperson of the International Association of Child Law Researchers. She's also widely acknowledged as a legal expert in the area of international child abduction and international children's law, and has published widely in her areas of expertise. Then we have amongst us Dr. Onya Momo, who is an English barrister and a lecturer in private international law at the University of Aberdeen, having previously undertaken a postdoctoral fellowship at the UK Research Assistant on the EU-funded POM program, which is the project of abduction of mothers returning in return proceedings. In academia, her doctoral research examined domestic violence in the context of the 1980 Hague Convention. In practice, she is exclusively dealing with such matters and has been the leading junior according to Legal 500 UK for children law. She's also exclusively working in family law matters and international child law, children's rights and protection, especially in the cross-border context, inter-country adoption, gender equality, domestic and family violence, and the Hague Convention on Non-Proceedings. Then we have amongst us Jeremy Morley, who's joining us from the United States. We're so grateful to him for taking out time to do this at an early hour in the morning there. Jeremy Morley was admitted to the New York Bar in 1975 and concentrates in the international family law. His firm works with clients around the world and from its New York office with a global network of local counsels. Mr. Morley is the author of International Family Law Practice, the leading treatise on international family law in the United States, which is updated annually. He is also the author for the Hague Abduction Convention, Practical Issues and Procedures for Family Lawyers, which was published by the American Bar Association. He is the former co-chair of the International Family Law Committee of the International Law Society of the American Bar Association. He's also a member of the International Academy of Matrimonial Lawyers. We also have amongst us Mr. Anil Malhotra, who is a practicing advocate in the High Courts of India and also the Supreme Court of India. He's got a degree from SOAS and LSE and has focused his practice area on international family law for 37 years and continues to act as a legal expert to render reports in foreign countries on appointment by the benches in overseas jurisdictions. We're extremely grateful to all our speakers for taking out time for us and for doing this. We're honored and we're obliged. And now hand over the floor to our first speaker, Professor Groff. The floor is yours.
Thank you. Thank you so much, Ankit. Let me just share my screen. Excellent. Okay. So in my brief 15 minutes, I shall just set the stage talking about two very important international treaties in this area, the 1980 and 1996 Hague Children's Conventions, based on my work over a decade at the Secretariat that administers these conventions. And these are very widely ratified international treaties and really are the preeminent instruments at the international level. So I'm just setting the stage, and India is not yet party to either of the conventions, but hopefully as dialogue progresses, this will indeed happen. And just a note that today I'm speaking in my personal individual capacity and not on behalf of any organization. So first of all, the body that administers these two important treaties is the Hague Conference on Private International Law, or the HCCH, which is a very old intergovernmental organization developing binding treaties. There's about 39 of them binding and one soft law instrument. And these treaties really seek to establish practical outcomes for people and businesses on the ground, dealing with very classical private international law issues such as jurisdiction, applicable law, recognition, enforcement at the international level, but also very vital cross-border legal cooperation. There's 91 members at this point of the Hague Conference, has very robust global reach. Membership growth has been very steady, as has the accession or ratification of the many different core Hague treaties. So there's about 156 states connected with the Hague Conference at this moment, party to one or more treaties. And you can see the whole range of treaties and the growth of membership. So this is just basically what we're dealing with as a global society. There's more and more demand for the resolution, the dealing with these cross-border legal issues. And of course, particularly poignant and important is the issue of cross-border child protection and parental custody disputes in a cross-border context. And just also to give you a note about what's involved with developing these international treaties, is not just negotiating and adopting the black letter law of the treaty itself, but there's a whole lot of post-convention work that needs to happen on the Secretariat's part with regional offices in Asia, in Latin America, around the world, really working with judges, government officials, practitioners to to monitor these conventions, to try to help them work in the optimal way possible, and also to evolve in terms of keeping step with social developments and legal developments in various jurisdictions. So today, as I mentioned, I'll just talk very briefly to give you an overview about the 1980 Child Abduction Convention and the 1996 Child Protection Convention, but I just also wanted to mention the very important 2007 Child Support Convention. If anybody watching is interested in international child law, protection of children at the international level, and indeed at the national level, this is a very, very important treaty also to look at in terms of children's rights and ensuring children get the proper child support in cross-border circumstances. So India is not yet also a party to the 2007 convention. So I would just invite study and making raising of awareness about that very important convention. So the Hague Children's Conventions as a set of conventions seek to give effect to various human rights of children enshrined in the UN Convention on the Rights of the Child. You see a list of those rights here. For example, the child has a right to stay in contact with both parents, even if the parents are separated across international borders. States must combat the illicit transfer and non-return of children, be it that illicit transfer or non-return of children, be it by a parent or another party. States party have to prevent abduction, sale, traffic of children generally, but parental child abduction is also a phenomenon covered. So those are just some of the provisions in the UN CRC which are addressed and in fact implemented in a way in these various Hague Conventions. And I just wanted to also make the note that these are some of the core provisions in the UN Convention on the Rights of the Child furthered by these treaties. But that doesn't mean this is without prejudice to the other obligations of states in the UN Convention on the Rights of the Child. For example, to protect children from violence, including domestic violence, which a colleague will talk about later. So these rights of the child have to be considered as a whole and operationally also as we implement these treaties or we implement these different provisions and approaches to international parental child abduction. So the 1988 Child Abduction Convention has 101 contracting states. So this is very widely ratified for such a technical convention, I would say. And it's been worked on by the member states of the Hague Conference and also the more recent contracting states from all legal traditions from very diverse parts of the world to really figure out how we make this convention operate in the most optimal way possible, dealing as it is with these very highly sensitive interparental and child custody issues. So there have been a number of initiatives that have sprouted up to surround and support the 1980 convention that I'll just mention. For example, the Malta process, trying to bring in and have dialogue with states that have a Sharia law legal tradition, and also the International Hague Network of Judges, which I'll talk about if I have time at the end of this presentation. So the principal objectives of the 1980 convention is really to protect children from the harmful effects of their wrongful removal or retention by typically a parent to another foreign jurisdiction to ensure their prompt return, to make sure there is continuity and stability in the child's life, and to avoid forum shopping, parents trying to take an unfair advantage by taking a child abroad. The basic requirements for the convention to be applicable if a state is party to the convention is a child should be below 16 years of age and was habitually resident in the contracting state from which she or he was removed. And the removal of that child constituted a breach of custody rights. And the applicant had to be actually exercising these custody rights at the time of removal for the child to be considered to be for a return order to the home state. So the remedy is really the swift return of the child to restore the child's life in the state of habitual residence. But there are a number of very important exceptions, which are listed here on this slide, to the return of the child. For example, if the child is grave risk of harm, there's discretion if the child objects to the return, fundamental principles related to human rights, et cetera. So these are also very, very important exceptions that give life to the convention, and that judges also must take into consideration when they hear an application for return of a child. And also, very importantly, there are provisions for these central authorities that help the convention operate to take all appropriate measures to secure the voluntary return or to bring about an amicable resolution of the dispute between parents. Of course, these are family matters, and this is often the best possible result to have an amicable solution. Now, I just want to touch briefly on the 1996 Child Protection Convention, which is a very important international child protection instrument. It now has 53 contracting states. So it should also build ratifications now over time. And it's quite a technical convention dealing with issues of private international law, yet really fundamental issues that will help children and their families in these cross-border circumstances, which are now commonplace in our globalized world. So I would just really urge, also states to consider, ratifying as a package the 1980 convention, the 1996 convention. So the 1996 convention provides rules on jurisdiction, applicable law, and ensures the recognition and enforcement of protection measures amongst all contracting states. Again, has these linkages to the UN Convention on the Rights of the Child. And it's really seeking to protect children in these international settings, which again are just all too common in our globalized world, and to prevent conflicting legal decisions between different states. And there's very robust authority, judicial cooperation, enabling provisions in the treaty that are also very important, so that the child can be put at the center of these cross-border issues. And this is just a slide that shows the complementarity of the 1980 and 1996 conventions. Just one I'll mention under the 1996 convention, there are provisions that the state seized of return application can take urgent measures to protect a child who can then be safely returned is the objective, with enforceable protective measures if necessary, and this back to the state of habitual residence. So these conventions very much complement each other and try to provide really a lot of protection and safety for children in these various circumstances. Now, lastly, I just wanted to mention, again, this very important support that has grown up and evolved organically around the 1980 Hague Convention due to, a lot of judges located in jurisdictions all around the world being very, very passionate about making sure they have the resources and the tools where they can deal with these sensitive issues of cross-border parental abduction or other situations where children are at risk in cross-border situations. This International Hague Judges Network has evolved over the years to now constitute 148 judges from 88 states. So this is quite extraordinary, I think, also, if you look at the context and the evolution of international law, to have this direct judicial communication possibility among judicial peers in countries all around the world. And I just note that you don't have to be a party to the 1980 convention or other Hague Children's Conventions to join the network. States have often designated judges to this network who then can start to share information across borders and have other types of direct judicial communications in the interests of children. So in this network, there's a general information sharing function. And then also there can be a very practical sort of logistical and more very focused on an individual case function that the International Hague Network of Judges can take part in. And there have been developed safeguards and principles that judges can follow so that they can safely do this cross-border cooperation and dialogue with proper safeguards within their own unique procedural legal system. So I think I will stop there. That's just a very broad and quick overview of these two principally very important international conventions. And I welcome students to really dig into them further and to really understand all of their various features and resources, because they're really invaluable in terms of the international cooperation necessary if we're going to ensure that we have a cross-border protection of children, given mobility and given globalization. Thank you very much.
Thank you, Professor. I now invite Professor Freeman to share her presentation with us, please.
So hello, everybody. I'm actually not going to share, if that's where I'm going to talk to it, but I would be delighted to send a copy to anybody who would like a copy of the PowerPoint. If you get in touch, perhaps with Ankit, or you can contact me directly if you like. So what we're going to talk about now are the long-term effects of abduction, as reported in my research, by previously abducted children who are now adults, both when they have been and when they have not been returned. And we'll also briefly consider protective abductions undertaken for protective reasons, including domestic violence to the abducting parent. But I won't focus overly focus on that, because somebody else is going to discuss that in more detail. But just to consider whether there may be any difference in the impacts and effects from that kind of abduction. And then we will just touch on the aims of the 1980 Hague Child Abduction Convention, which Maya's already drawn to our attention. So that's really helpful, because it means that we've already got some understanding of that. So just about the context for this discussion, because this is international child abduction. It is still a global and a growing phenomenon. Abduction is usually harmful. And that's even when the children are with their primary or joint primary carer parents. They still often suffer many significant and harmful effects from the abduction. A wrongful retention or removal away from one parent and the child's home country probably changes the child's worldview permanently and irretrievably, so said Justice Victoria Bennett. And returning the child to the state of habitual residence may also cause harm to the abducted child, and that may be experienced by the child as a geographical rather than a psychological phenomenon. So a return which is more apparent than real. Again, that was from a quote from Justice Victoria Bennett. So the research, there's a research sort of line of research that I've undertaken, and that's detailed in the PowerPoint. But I'd like to really talk to you about two pieces of research. One was in 2006, which was the Effects Project, which I undertook for an organization called Reunite, which will be known to many of you. It's the International Child Abduction Centre based in the UK. And then also the research that I undertook in 2014 on the long-term effects of research, and that can be found very easily. If you just Google me, you'll find that, but I'm delighted to send that to anyone who wants it. So let's just look at this, because when we did the effects research, looking at the effects on the child from the perspective of the parents, so the parents in that research were saying that a high percentage of those parents were saying that they thought there had been effects on their children from the abduction. And they detailed those effects as both physical and psychological. And particularly they said the non-physical symptoms included a lack of faith in the legal system and in adults in the lives of those children, and that the children had learned coping strategies like blanking out. And also that the children, the parents perceived, felt a general lack of trust after the abduction. So I emphasize those because I'm going to come back to those shortly. They also talked about how there were tensions in familial relationships when the previously abducted child was living with non-abducted siblings and new family members on return. So those were things that were spoken about by the parents back in 2006. They also spoke some of them, about the psychological barrier that had been created between the abducted child and the left behind parent, because on return, they both knew, that's the left behind parent and the previously abducted child, that they had in fact got through this. They had survived this period of separation and their lives without each other, and that they had both lost their faith in their reciprocal need for each other. And that's something which we don't have time to go into much now, but I just leave that, just plant that with you to think about that, because that's a huge emotional barrier to deal with. They also spoke, this is the parents, about how the kids are back and that's the end of it. That was the feeling that they had, that the emphasis was rightly on trying to get the child returned for the reasons that Maya pointed out to us already, because the convention is focused on the need to return children promptly to their state of habitual residence, so that the decisions about their future can be taken in the place which is best connected with the child. But that the parents felt, well, that's the end of the story, that no one's interested in what happens next, how the children or the families adjust. So these were observations that were made by the parents, but we also undertook interviews with the children, children who had been abducted, and these interviews were conducted by members of CAFCAS, which is the Children and Family Court Advisory and Support Service in the UK. And these are people who are very experienced in child interviewing in abduction cases. And 70%, it was a small sample. There were, as I believe, there were I think 10 children involved in this. There may have been a bit more. 70% who had been abducted by their mothers, and they all described their mother as their primary carer, and they did not experience their mother as the abductor. And 30% who'd been abducted by their fathers, and none of those children considered the father to be the primary carer, and these children did tend to see the father as the abductor. And what did these children say? They said they wanted an end to the ongoing proceedings. They hated to hear negative things about either parent or to feel they had to defend either parent. But they made an important point, that the return of the child can be as upsetting and as stressful as the original abduction, and that all those children were found to have been adversely affected in different ways, notwithstanding their age and stage of development. So that was an interesting basis, but also additionally, a very small number of adults who were abducted as children contacted me because they'd heard about the research and they wanted to be involved in it. And that was extremely interesting, because these were adults who obviously had something to say. They described the effects on them as lasting. They particularly described the problems of loneliness that they had experienced, the insecurity they had experienced, the lack of trust that they'd experienced, which in their view was entirely attributable to the abduction, which they said had destroyed their lives. And they emphasized the importance of research, because they said, this is why they contacted me. Somebody wants to know what happened. So that led on to the long-term effects research, which was a small scale, about 34 cases. It was a qualitative study to find out about the lived experiences of those who had been through an abduction many years earlier, to learn whether and how participants felt that the abduction had affected their lives, and if those effects had continued long-term. And it's important to point out here that because this is looking at the long-term effects, abductions in this sample had occurred many years before, so between 10 years, and some of them had occurred much earlier than that. So many of these abductions occurred before the implementation of the 1980 Hague Convention, so possible that this may have affected the outcomes for those children, and also that the outcomes may have been different at earlier points in time. Also important to point out that the periods of time away before reunification, that's if reunification occurred, were substantial. So for the majority of those who were reunified, this did not occur until more than 5 years after the abduction, and more than 1/3 of the reunifications occurred after 10 years. And what I want to do now is just to give you a couple of research snapshots. There's much more detail in the report and also in the PowerPoint. But so the people who participated in the research talked about how hard they found to let people in, how they were not good at intimate relationships because they had a constant sense of insecurity. And remember, going back to that 2006 research, these are some of the words that we used then: constant sense of insecurity, blocking things out. Again, that resonates with what we heard earlier. Being numb for much of their childhood. Everything can be so easily taken away. Unfortunately, mental health problems, suicide attempts, depression were constantly mentioned through these research undertakings and reports. Not feeling connected to anybody, big issues with security, lots of trust issues. That goes on, as I say, as a theme that is very obvious through the research. When we get to talk about reunification, some of the comments that were made were illuminative. So a particular woman who was abducted, she was 38 when I interviewed her, was abducted by her father when she was 3.5. She was returned by the court to her mother when she was 8. She describes that event as the kidnapping because she didn't know her mother anymore. She didn't recognize her. She said it took her about 3 months to realize that this was permanent and she wasn't going to be back with what she thought was her family again. And her mother, the left behind parent, intellectually thought that she was getting her young child back again. Of course, she knew that the time had gone in between, but she was emotionally stuck at the point where the child had been removed from her. And all the rules were, of course, different for both of them by then. The reunification did not work out, and at 14, she returned to live with her father. Again, I won't trouble you with all of the reunification comments, but that's that kind of comment, that it doesn't always work out, that in fact the reunification can often be the start of a whole new set of problems where people are left very often to just deal with this on their own, because aftercare and support is not easily available once the child has been returned. So the analysis on the data that emanated from the report was undertaken using various classifications: very significant effects, and no real effects. So the very significant effects were where the interviewee reported seeing a psychologist, psychiatrist, or being diagnosed with a condition like post-traumatic stress, suffering a psychotic episode or breakdown, being admitted to a hospital with mental health issues, having suffered depression or attempted suicide, that kind of thing. Effects were where the interviewee reported other discernible effects, but such as having problems with trust in relationships, lack of self-worth, fear of abandonment, panic attacks, and no real effects, minimal or no effects from the abduction. And what I would say is that there was a very high percentage of that, 73.5%, so a high percentage of the previously abducted children in this sample reported suffering very significant effects from their abduction in terms of their mental health. A very low percentage reported no real effects. The status of the abductor did not tend to alter the effects experienced by the abducted child. So that's unlike the earlier research where the children did tend to see if they were abducted by their mother, who was a primary or joint primary carer, they did tend to see that person not as an abductor. now, looking at the long-term effects, the status did not tend to alter the effects experienced by the abducted child. And those who reported very significant effects talked about the ongoing nature of those effects in their current adult lives, often very many years after the abduction. So the key findings, I won't go into them other than to have just highlighted those there for you. The report makes recommendations, and those recommendations are focused on the stated need which Maya drew our attention to in the 1980 Convention, on the need to protect children from the harmful effects of abduction. And the report asks, how do we achieve that required result? Well, one way of protecting children from the harmful effects of abduction is to prevent abductions from taking place. But another way is to provide the necessary practical and therapeutic support which is required for the child and the family to adapt successfully to their experiences and new circumstances. So just briefly, prevention, well, whilst it's accepted that it's not possible, and I would query even desirable, to prevent all abductions, and I'm going to link this into what you're going to hear from Anya Moma shortly in relation to domestic violence, I nonetheless submit that preventable abductions must be avoided, and the report makes recommendations regarding prevention. And as far as support and care recommendations are concerned, well, children are not being protected from the harmful effects of abduction without being provided with appropriate information, support and care for themselves and their families to help address the abduction event that has occurred. So again, I'm not going to go into that, but I'm keeping very closely to the time that's been allocated, but I've just say, what are the takeaways from what I've said to you today? Well, parental child abduction needs to be understood for what it is. It's an important matter with potentially extremely serious negative effects for the child and the others who are involved in the abduction event, but including future generations. It's not just now, it's about what happens with relationships, what happens with parenting, and how that trickles through the generations. So the impacts of abduction may continue into adulthood, affecting well-being, health, personal relationship choices, and outcomes. I would say it is not a benign victimless event, which sometimes happens within families and that we just shrug our shoulders about. It is a societal problem, and it's not merely an individual family issue. We readily acknowledge that these events will inevitably cause ripples on the oceans between lives lived currently in different countries and on different continents. But the research, not just mine, other research, has also shown the inherent potential of these events to ripple through the generations and affect the society we will become, as well as the society which we are now. We ignore these issues at our peril, and we may not be able to do everything for everyone. I accept that, but we can do more for some, and I leave you with the thought that we should do what we can. Thank you very much.
Thank you for your very insightful words, and sort of reminded by this famous quote by Khalil Gibran, who said that your children are not your children. They are the sons and daughters of life's longing for itself. Perhaps it's the longing which acts as the barrier to yield to parents to adopt such measures. I now turn to Dr. Momo to share her presentation on this topic. The floor is yours. All right.
Thank you. I think my slide is on the screen. Is that correct?
Indeed.
Thank you very much. I'm really grateful for the opportunity to talk about the POAM project, so POAM, which was a project that was led by Dr. Katerina Trimmins at the University of Aberdeen. So the POAM project, which I will come to explain in a moment, looks at, in the most simplest of terms, how the 1980 Hague Convention is utilised in the way that it was intended to to protect children. And how does it do so? Well, as you've already heard from Professor Freeman and Professor Maya Groff, the removal or the retention of children away from their country of habitual residence suddenly or sometimes gradually, say for example a holiday turned permanent, is an action that is usually mostly contrary to their welfare. And so returning the children to a country that knows them best so that their welfare can be properly considered, determined, is the aim, the overall objective in a nutshell. But you see, that return ought to be safe. So the question is, well, whatever is the point of returning a child to a country or that country of habitual residence, if to do so would be to put that child in a risk of further harm? And I'll come on to Article 13.1b in a moment. So Professor Freeman's research on the outcome of children and return following abduction is indeed incredibly insightful. And amongst other things, I know I don't think was touched on, is something that I got from that research, for example, in relation to the unenforceability of measures, so say undertakings, which was a serious problem for parents, particularly those who were victims of domestic abuse. Now, the POAM project, which stands for the Protection of Abducted Mothers, I use that word carefully, abducting mothers, but it is or was an EU-funded collaborative research project which explored the intersection between domestic violence and international parental child abduction within the European Union. Certainly, it started when the UK was still just within the European Union in 2019. So the project was concerned with the protection of mothers who've been involved in return proceedings under the 1980 Hague Convention, Brussels 2A regulation, in circumstances where the abduction was motivated by acts of violence from, say, the left behind parent. So a parent, a primary care parent, fleeing the country of habitual residence with their child on the premise that is their only way of getting away from abuse. So the work focused on preventing and combating gender-based violence and violence against children in the context of international parental child abduction. So POAM looked at two particular instruments, the Regulation 606/2013, so the European Protective Measures Regulation, and also the European Protection Order Directive of 2011. And it was launched, as I say, in January 2019, and it involved the Leeds University, Aberdeen, Dr. Katerina Trimmins. I was the research assistant for the UK, as well as 3 partner institutions. So Germany was Professor Anatol Dotter at the Ludwig Maximilian University. At the Milano Bicocca University was Professor Costanza Onoati, and at the University of Osijek was Professor Mirella Zupan. And so, as we know, it was funded by the EU and continued until just the end of the end of last year. Now, in broad terms, the idea of the intersection between domestic violence and parental child abduction sort of hinged on 4 important scenarios or points to flag up. So that the majority of abductions were committed by mothers, and there were frequent incidents of domestic violence being raised within Hague Convention proceedings. I'm not going to delve into the statistics. And so therefore the exception to return, Article 13.1b, the grave risk of harm exception, was something that was used or rather evoked frequently and needed to be addressed or approached appropriately by courts, by judges. Now, the POAM project looked at the gap in that the safety of mothers upon return was in many situations, many scenarios, as equally important as the safety of children, particularly primary care and mothers. And so in a nutshell, the legal framework pertinent to parental child abduction, as we've seen, is the 1980 Hague Convention, but within European Union, Council Regulation 2201 2003, so Brussels 2A, which is, of course, currently subject to a new treaty, new council regulation coming out very soon. I won't rehearse the aim of international parental child abduction in terms of the 1988 Convention in tackling the problem, and of course the underlying premise in that the wrongful retention removal is wrong, is generally contrary to a child's welfare. I've set out briefly the justifications, I think that was alluded to by Professor Groff, in relation to where perhaps a wrongful removal or retention of a child may lead to what is often referred to as a non-return order. So we have Articles 12.2, Articles 13 and 20, in essence, human rights, the objections of a child, grave risk of harm. I'm going to focus very quickly on the grave risk of harm. I make a note of the Brussels 2A regulation, which essentially reinforces the principle of the prompt return of a child. Now, as part of the POAM project, the idea was we pulled out some quite important background issues. Firstly, as I've alluded to, primary care mothers as abductors, or certainly as the parents removing their children, as opposed to what was initially intended when the Hague Convention came into play, or certainly was being discussed back in the late 1970s, 79, 80. So the vulnerabilities of returning mothers in abductions committed against the backdrop of domestic violence was something that was highlighted, particularly the re-victimization upon the return of that parent, the lack of financial or emotional support, perhaps the possible dependency on the left behind parent and post proceedings. And also, and I've seen this unfold, particularly in cases that I've done, the idea of the lack of credibility as a respondent in return proceedings that have failed, and therefore the idea that perhaps there's a huge question mark around the incidence of domestic violence in the state of origin, the difficulties with evidential obtaining the evidence that would assist in cases like that, and also exposure to what is referred to as intimidatory litigation, whereby there are instances where the left behind parent, say the father, would perhaps use return proceedings as a means of further harassment rather than a genuine desire to secure the return of the child. And so Article 13.1b, if I may, as underlined there, says that notwithstanding the provisions of the article, so notwithstanding the objectives of returning children to their country of habitual residence, that return could be that the state, or rather say the judge who's hearing the case, is not bound to make a return order for that child if it can be established that there is a grave risk that his or her return would expose the child to physical, psychological harm, or otherwise place the child in an intolerable situation. So physical harm, psychological harm, or an intolerable situation. Now, there are a number of important background issues, therefore, when you bear in mind the idea of the grave risk of harm, physical harm, psychological harm, intolerable situation. And so the safety of abducting mothers upon return, the wording of Article 13.1b, it's important to note that firstly, the situation of a child is the prime focus, not the parent. And that's important because ultimately this is a child's convention. Nevertheless, of course, the consideration, it would seem, of the safety of mothers upon return is not something that you see in the convention or the Brussels regulation. Having said that, the Hague Conference has on several occasions recognised the importance of protecting children, and to do so sometimes requires taking the steps to protect an accompanying parent. The Guide to Good Practice on Article 13.1b re-highlights this very important point, as has many case law, particularly in the UK, in England and Wales. Now, there is a tension, of course, between the Convention's summary return policy and the considerations over the safety of the abducting mother, so mothers who may have removed their children. And all of that ties into the idea of the impact on timing in terms of addressing key considerations of the, say, the adequacy and the enforceability of protective orders. So I'll deal very briefly on that. So, safety of the abducting mother upon return. How does one tie that into what are supposed to be very summary return proceedings in the Hague Convention with quite tight timescales? So ideally 6 weeks. And then how does that deal with that in terms of ensuring the adequacy and enforceability of protective measures in the context of what are, again, very, very quick proceedings and tight timescales. Now, another important background issue really is the idea of determining that, well, we've got the harm to the abducting parent, so the mother, and the harm to the child. How does one determine whether, in fact, that child has been exposed to domestic violence in a way that establishes a grave risk of harm? So these are all issues that one has to grapple with within a tight time frame. Hence, for example, we now have as I've mentioned, the Guide to Good Practice to assist practitioners and the judiciary in determining these sort of issues. So it's important to note, of course, that domestic violence can take many forms. It's not limited to physical violence. It can extend to psychological, emotional abuse, and that children who witness domestic violence, so violence directed towards a parent, can be seriously harmful to the child who witnesses that abuse or who depends upon the psychological health or strength of their primary carer for their health and well-being. So the impact on the parenting capacity of a person who has suffered domestic abuse. So in essence, and finally, the risk to the abducting mother is intertwined with the risk to the child, and therefore may justify findings that children are at risk of psychological harm or an intolerable situation, which as you know, of course, will fall under Article 13(1)(b). Then just briefly in relation to preliminary considerations when one considers how to go about the nature and the type of protective measures, or the relationship between protective measures for the child and how that would be protective measures for the mother, or rather protective measures for the mother, and how that trickles down to protecting the child as part of the package. Firstly, protective measures that are available, one has to look at the general features of the state of origin, say access to court, other legal services, perhaps housing assistance, financial assistance, women's shelters, and the responses by the police, means of support for victims of domestic violence. In addition to that, also, you of course have, I think it's incredibly important that when courts consider protective measures that could be put in place, they look at the civil or criminal protection orders that are available that could ensure the enforceability of those measures, ensure that those measures can then be enforced once they reach the country of habitual residence. So where the Poem Project is concerned, it looked at Regulation 606 and how countries could impose, or rather, measures of protection and send a return order with a raft of measures that another country can easily recognise cross-border. In the context of countries outside of the EU, we looked at the 1996 Hague Convention. We already know that mirror orders are something that are also used amongst other common law jurisdictions, for example, in terms of ensuring the enforceability of protective measures. And so one of the key points that, and I won't say it's come out of the Poem Project, it's something that has been highlighted in case law, and particularly those that we looked at in the UK, and also within the Hague Conference, the Guide to Good Practice, which is understanding that protective measures for a parent, for a mother, can be, by extension, measures that protect a child. So a court is expected in instances of domestic abuse, particularly those perpetrated against a parent, but perhaps not directly towards a child, but a parent who is a primary carer, parent who is often left with no choice but to return with the child if a return order is made, that there is that understanding that measures for a parent is just part of an important aspect of determining whether that return can be safe. There's a distinction between protective measures and soft landing measures. Soft landing measures such as paying for return flights or providing financial support. We looked at various aspects of domestic, so the various scales of domestic violence, and this isn't to minimise any level of domestic violence, but in terms of those that perhaps could be ameliorated and those that cannot. But in terms, and so therefore, in terms of looking at soft landing measures, for example, perhaps put in paying for flights and financial support, those have to be distinguished from the measures that are so obviously relevant and important to properly ameliorate severe levels of physical or psychological abuse, or indeed in some circumstances, as the courts have found, these levels of psychological harm, say towards the parent, are ones that just simply cannot be ameliorated. So in determining protective measures, it's important, and I won't go into this at all, that the approach to examining the grave risk of harm, to examining allegations of domestic violence, is undertaken in a manner that is, I would suggest, that works properly, one that examines the allegations or the veracity, the merits of the allegations. There are evidential difficulties in cross-border situations. The burden, the standard of proof, of course, say where the UK is concerned, is the balance of probabilities. The burden is on that parent who has taken the child. I've listed there things that may be available, may not be available. And this here you will find in the best practice guide, which looks at documentary evidence and oral evidence, if it comes to it, in terms of determining how one approaches, or rather tries to determine whether the abuse or the violence is such that the child would be at a grave risk of harm. And so, as I've alluded to, the approach to the assessment of the grave risk of harm is an important aspect of the case in determining, in any case involving allegations of domestic violence. So assessing the merits of the allegations, determining whether the grave risk of harm exists on the basis of the domestic violence suffered by that parent that has impacted on that child. Does the grave risk of harm exist for that child? Has the child suffered psychologically as a result of seeing and witnessing the abuse to such an extent that returning to that country would be harmful? And then are there measures of protection available to protect, i.e. the mother, from the abuse and by extension the child? And in summary, the best practice guide, the POEM project, which is available on the website, provides a number of recommendations. And in summary, it looks at the importance of recognising that child abduction is motivated by domestic violence, that the risk of harm to the mother and the risk to the child may be so intertwined to the extent that, even though this is the 1980 Hague Convention and the focus is on the child, it is such that domestic violence directed solely towards a parent could constitute a grave risk of psychological harm or an otherwise intolerable situation for that child. And so accordingly, protective measures for the abducting mother should be considered as protective measures for the child. The best practice guide goes into further quite specific details as to how one may approach various measures of protection depending on case by case, depending on jurisdictions, depending on the circumstances of the case and the confines of national law. So we looked at the UK, Germany, Croatia, Italy, but also Slovenia and Spain as part of an additional tranche of support. And I mean, I think that ultimately the utility of Regulation 606/2013 in EU cases is one that we say needs additional, needs to be used more. In terms of the 1996 Convention, I think Professor Freeman and Mygrove have already made the point about the usefulness of that in the context of protecting children's or ensuring the enforceability of measures when they leave that country, to return to the country of habitual residence. So in summary, the website, the POEM Project website, has a number of resources: the best practice guide, training materials, national reports from various countries, and expert information, and a video as well. Have a look at that, and hopefully this has given you some sort of brief overview in relation to specifically domestic violence in international parental child abduction cases. Thank you.
Thank you. Thank you so much for your expert thoughts. I now invite Mr. Morley to share his expert thoughts. Sir, the floor is yours. You have to unmute yourself.
Okay. Hi to everyone from the Big Apple in New York in the USA. Let me move on from my website. So what am I going to cover? I'm going to cover primarily what I see in my practice as a very busy international family lawyer, especially about kids and especially about the Hague Convention, because that is a large part of our work. But we also have a unique unique statute, which we call a uniform law, that is in force in every American state with minor exceptions, that also relates very, very much to cases of children and across international borders. Just getting started and speaking to a law faculty with students that are embarking on their career, question arises as to what is international family law, and I'm an international family lawyer, and just in a preparatory way, we just say that international family law, there's really no such thing as. It's really domestic family law as it applies to the international aspects of a case. My practice is phenomenal because every case is weird and different and unusual, and involves us looking at the situation of international families with all kinds of international connections, whether it's to do with children moving from one place to another, spouses moving from one place to another, marriages that may or may not be valid in different places, assets that may be located globally, and trying to figure out for a client where to start. What is the first step is often the most important issue in many of these cases. Where do I bring the case? Where do I start? How can I sort out this amazing mess when family law is usually domestic, but my case is international? So that's what continues to intrigue me in the many, many cases that cross over my desk. Although international family law is primarily domestic law and looking at the comparison of domestic laws between the relevant countries, it is international to the extent that there are treaties, and you've heard today so far so effectively about some of those international treaties. The one that I work with the most is the Hague Abduction Convention, which is a revolutionary agreement, a revolutionary document, because it embodies the brave decision made so far by more than 100 countries to defer any decision about what's best for children who have been wrongfully removed or retained overseas, to defer that until they've been sent back to the country from which they were taken. Or, put it another way, often to respect the decisions that have been made by the courts in the country of the children's habitual residence. Remember that so often abductions come after a court in the country where the child is living has made a decision, and yet somebody has got on a plane, taken a child away in violation of the decisions and the orders of the courts of the habitual residence. The deal that is expressed in the convention is we will return kids to you so that in the future you'll return our kids to us. And it's critical that that mutuality be understood and respected. And the more we allow exceptions to be expanded to this fundamental principle, the weaker the treaty becomes. The treaty requires expeditious treatment. The target date is to decide a case fully, including appeals, within a target date of 6 weeks. That is extraordinary. My country breaches that every day of the week. And I'll get back to that in just a moment. The Hague Convention does not make custody decisions. All it does is say that those decisions should be made by the courts in the place where the child is living, not in the place where the child is taken to wrongfully. That's a critical distinction. Do we respect the courts in the place where the child is living? Well, if we accept them as a treaty partner, then we are respecting the integrity of their legal system. And if their legal system has made a decision about custody matters, about whether a child should remain here or be taken away, then we should respect that. Right now, the United States is faced with an accession to the Hague Convention by several countries that our State Department is considering whether we should or should not accept their accession. Will we accept the accession of Russia to the Hague Convention? I hope not. And there are some other countries on that list. Not that I want to be outspoken, but my goodness, that would be horrific. The convention requires judges to be brave, to put kids onto a plane when perhaps there is even an uproar. I remember doing a case in Hungary where we won the case, we lost the case at first instance, we won it on appeal, and then there was another appeal to the Supreme Court of Hungary, we won the case, and then the Hungarian parent was on television. There was an entire night of Hungarian TV about how terrible it was that a Hungarian child who had suffered abuse in the United States was now being put on a plane, and they had cried, they had tears, and they had outrage, and they had grandparents, and everybody was complaining that this was bullying by the foreign government, in this case, the US government. And guess what? The Supreme Court changed its mind because they were not brave enough. So it's tough to implement this treaty. It is based on the greater good concept. The best interests of a particular child might possibly not be served by returning that child to the country from which he or she was removed, but the interests of children at large are best served by ensuring that abducting parents are not rewarded for their misconduct. There are some exceptions to the treaty. They need to be interpreted very narrowly, otherwise the entire treaty is swallowed up by the exceptions. The concept is one of deterrence. International child abduction is child abuse. Our US Supreme Court has so ruled, and that we should deter people from violating the law and taking their children overseas when it's done without the consent of the parent who has custodial rights, or when it's done without the approval of a court. Japan is an interesting case. The family on the bottom left, that's a client of mine. We went public with this a number of years ago before Japan signed the treaty. Japan was the world's #1 safe haven for international child abduction, at least in terms of complaints about it. Hundreds and hundreds of children were abducted to Japan. Japan was not a Hague country, and Japan had a legal system that was utterly and completely useless in the area of family law. Family court orders from Japan are still rarely enforced. There's basically no system for enforcement. So whenever a marriage broke down typically between a Japanese mother and a non-Japanese father, and they were living in the West, or they were living anywhere in the world, upon the breakdown, the Japanese mom would, and it's not only moms, but it was usually moms, would get on the plane and take them back home to Japan. If their passport was held by the court, they could go to the Japanese consulate and get a new passport. And because the Civil Code of Japan allowed only one parent to have custody, and still only allows one parent to have custody even today, then and allows very, very, very limited visitation rights that are basically unenforceable, then the non-Japanese parent would always lose just about all access to the child. Chris Savoy, who's the chap on the bottom left, his kids were abducted from Tennessee. Tennessee court order was violated. He went there and picked the kids up from the street and took them to the closest US consulate. He was arrested by the Japanese police as he was about to enter the US consulate. He was put in jail for 18 days. He was let out after a gigantic outcry. We were on TV every day and we made a gigantic stink about this. This was the cause célèbre. Chris has not seen his children since. This goes back many years, but Hillary Clinton got interested in the matter. A huge outcry occurred. We got the press very interested in the situation. We explained also that this was actually this system of authorizing basically child abduction to Japan was hurting many Japanese parents because because if you were concerned that your child was going to be taken for a visit to Japan and then kept there, then you would go to court in the United States or in the UK or wherever it was, and you would seek a court order to prevent even a visit to that country because the danger was so high. And so we explained that this was hurting Japan's policy. Sorry, this was hurting Japanese parents living overseas, that they could never take their kids for a visit. The same thing is occurring right now, with, for example, with respect to China. China is not a Hague Convention country, and it does not return abducted children, usually, especially if the abduction was by a Chinese citizen. And so the result is that Chinese parents living, for example, in the United States, who want to take their kids to visit China and to visit their grandparents and visit their family, which is usually a very good thing, they are usually not allowed to do so if the other parent makes a good faith objection. As a result, I testify as an expert witness all the time, explaining that I've worked on cases of abductions to China and to many other countries, and that the legal system there is terrible, that it is a red flag, that China has refused to sign the Hague Convention, even though more than 100 countries have done so, that its legal system doesn't work in the area of family law, and especially in the area of international abductions, that their courts may not even open their doors to foreigners in this kind of a case, and that there is a huge risk. We compare that to what we call the red flags or risk factors of potential international child abduction. And in most of those cases, if there is a good faith concern by the potentially left behind parent that the kids will not come back after a visit, the US courts will not allow a visit. And that's not fair to the kids and it's not fair to the families, but it's a lot better than allowing an international abduction to occur so that the father, assuming that the left behind parent will have no significant continuing access to the child thereafter. The same applies to countries that have signed the convention but do not comply with it. Our US State Department is required to submit annual reports to Congress on whether treaty partners are in compliance with the treaty. Brazil is an example of a country that is not in compliance with the treaty. Therefore, it is very difficult for Brazilian parents to go for a visit from the US to Brazil if one of the parents objects to the visit on the grounds that there's a significant risk of potential international child abduction. I should say in passing, the same exact thing applies with respect to India, which has not signed the Hague Convention. This is the cover page of one of our most recent annual report. And this is the current page on Japan, which says that the convention has been enforced between the United States and Japan since 2014. Japan was previously cited for demonstrating a pattern of non-compliance. and that it is now colored green at the top. And what does that mean? It means that our State Department says they are compliant. And if you look at the chart, you will see the total number of abduction cases for 2020, new abduction cases, seven only, as compared to dozens and dozens and dozens and dozens before they signed the treaty. And that is because my friends at the Office of the Central Authority and the Ministry of Foreign Affairs in Japan have worked very, very hard to educate the expat Japanese community that if you abduct your kids to Japan, they will be returned to their country of habitual residence. So hats off to these guys and to all those who have done a job of ensuring that Japan takes the Hague Convention seriously, and it has created effectively the result that Japanese parents living overseas are now deterred from stealing their children and are instead encouraged to use the legal system in the place where they're living to provide the protection that is needed in the event that there are claims, in the event that they're suffering domestic violence, or in the event that they need financial resolution of divorce cases, for example. I won't go on and on about India. Anil will be discussing that, and he doesn't need to listen to me again going on and on about India. But this is the U.S. big stick that India is non-compliant as far as the United States is concerned, and there are 66 cases where abduction cases that the State Department in the US has tried to help on of abductions to India have been unresolved for more than a year, and 27 have been unresolved in India for 4 years or more. Problems with the convention. Let's turn this off. Let's tell you that I'm already out of time. Can't be. The problems with the convention that I see, and there are significant problems. The first one is you heard very effectively just now a discussion about the grave risk exception. It is ambiguous. It contains language that nobody knows really what it means to say that psychological harm, physical harm, or otherwise place a child in an intolerable situation. The exception was enacted to deal with exceptional cases. The problem that I face in practice is that it is used in almost every case under the Hague Convention, because it is the only one that it's the one with the most ambiguity. So if you have a client who has abducted a child and there's always a justification for it, you will search for any way to claim that there's an intolerable situation, there's some kind of risk. In our legal system in the United States, we don't have judges that are specifically trained on Hague Convention cases, and they are too often succumb to the what we will consider the need to consider very carefully the allegations that are made as to risks to the children if they are returned. And this opens the door to a battle of the psychological experts. It opens the door to discovery, pretrial discovery. It opens the door to delay and to appeals. It opens the door to expense. It opens the door to an analysis of matters that the Hague Convention, I think, really was enacted to prevent. That is, we should respect normally the decisions that are made in the original courts in the habitual residence, or we should send children back to those courts unless it is clear that that legal system is unable to provide the necessary protection. That's my view, and I like to be controversial, so I'm coming straight out with that. The more you can delay a Hague case, the stronger your case becomes if you're trying to defend the case, because the the more it's dragged out, the more that the court is inclined to not return a child after all this time. Children are put in the middle. Children are put on the witness stand, which can be horrific, or they can be interviewed by social workers. But then we don't trust the social workers, so that we have to hire separate experts, and it goes on and on and on and on. And it is awful. And it becomes, in my world, in the United States, it becomes quite expensive, very expensive. I just want to make reference to a very important uniform law, which I just mentioned at the beginning, but it's our Uniform Child Custody Jurisdiction and Enforcement Act. There are two ways to get kids back who have been abducted to the United States. You can bring a case under the Hague Convention, or in most cases, you can bring a case in an American court under the UCCJEA. We treat foreign countries under our law as if they are what we call sister states. The UCCJEA, which is in force in 49 out of the 50 states, and the 50th state, which is Massachusetts, has a prior version of the same law. The act states that a court of the state shall treat a foreign country as if it were a state of the US for the purpose of this law. A child custody determination made in a foreign country under factual circumstances in substantial conformity with the jurisdictional standards of this part must be recognized and enforced under this law. The only exception, the so-called escape clauses in subparagraph C, a court of the state need not apply this part if the child custody law of a foreign country violates fundamental principles of human rights. It is very hard to apply subsection C, the escape clause. It is because in almost every state, it is held that you look only at the law as it is written. And most laws about child custody read pretty well. Most of them around the world talk about best interests or welfare of the children. And so they don't read they don't read badly. There are some that still talk about decision-making being based upon the age, gender, and religion of the child, and those would violate fundamental principles of human rights. But that's limited to a few countries now. The home state of the child is the place where the child has been living for the last 6 months. A decision made by a court in a home state will be respected by an American court. The concept is that the decision made by a home state court, let me backtrack one second. Once a court in a home state has made a child custody decision, as far as every American court in the United States is concerned, that state or foreign country has what we call continuing and exclusive jurisdiction to handle all matters concerning the child, concerning child custody, unless the court in that state relinquishes jurisdiction or unless no parent is continuing to live there. What does that mean? It means that if there is a decision from a court in India that concerns child custody, that was rendered at a time when the home state of the child was in India, meaning that the child had been living there for 6 months prior to the commencement of the case, we will enforce that order. You can register it and you can enforce it. And there are basically no defenses. The only, and I said, there's always exceptions. So I just said, basically there are no defenses. The exceptions are due process. Was the defendant served with process and given the opportunity to appear? And was it the home state? That's it. The law says that you can register that Indian court order in New York. We can get a pickup order for the child. That's the colloquial term for the order that we would get, that after an abduction, we register the order. We sometimes will do it ex parte, and we will get an ex parte pickup order requiring the taking parent to appear in court the next day with the child and with his or her travel documents. And we will suggest to the Indian parent, if possible, that they fly in, come to New York, pick up your child and go back home. Period, the end. And that is an incredibly powerful tool. And so it is far better than going under the Hague Convention in many cases, because the Hague Convention might not be in force. It's not enforced with respect to India, or because the child might be over the age of 16 or about to become 16, or it might be a case of enforcing access rights. And the Hague Convention has visitation or access, has one provision, Article 21, about access rights, but they're basically not enforceable under the Hague Convention, or because the order made by the foreign court might come after the child has legitimately been removed to the United States, but still the foreign court has continuing and exclusive jurisdiction, and that foreign court might have changed its mind. Or it might be a way to avoid a problem when a question about habitual residence is unclear, that there is no definition in the Hague Convention of the key term of habitual residence, but the term home state is much clearer. And it's there may be financial concerns, and going under the UCC is much cheaper. And most importantly, the defenses or exceptions under the Hague Convention do not apply under the UCC, for UCCJEA pickup order. Grave risk does not apply as a defense. So that's something that's most unusual about our US law. I think at this stage I've gone far over my time, and I'm delighted to turn over the time to my good friend, Mr. Malhotra.
Thank you so much for your expert comments and also being so candid. We do appreciate candidness. And now invite our final speaker to share his perspective, and not as a rebuttal to the points made, but also as a standalone presentation, the Indian perspective and the global perspective from an Indian and international perspective. Mr. Malhotra, the floor is yours now, please. You'll have to unmute.
Thank you very much. What an illuminating professional discourse by Jeremy after a brilliant academic exposition by Maya, Marilyn, and Dr. Momo. All the M's and one M that side, and the fifth M is here before you. I don't know how you landed up all the M's together today. Anyway, that apart, we are a different jurisdiction. You all know it. I always look at what Tennyson says, being melodramatic. His famous poem, "Child is the father of man." An infant crying in the night, an infant crying for the light, and with no language but a cry. The research by Marilyn, the research by Maya, and the research by Dr. Momo all points out to this, that a child who is removed or abducted has no voice. And I remember Marilyn's very innovative research on the voice of the child, which was very thought-provoking and very engaging, that this is something which needs exposition. That apart, we are 1.2 billion plus, 29 states, 7 union territories, 3.28 million square kilometers. A high court in every state with subordinate courts under the jurisdiction of the High Court, and above all the High Courts, the Supreme Court of India. Law laid down by the Supreme Court of India under Article 141 of the Constitution is the law of the land, is binding on all. Now, just to put the perspective in the issue pertaining to the Indian laws are concerned, Let me give you a little background. We do not have any uniform civil code, which means every individual religious community has its own codified personal law made by the Parliament of India. The majority of us who are Hindus by religion are governed by the Hindu Marriage Act for marriage, the Hindu Minority and Guardianship Act for minority and guardianship, the Hindu Adoption and Maintenance Act for adoptions, and so on and so forth. The Hindu Succession Act also for reasons of succession. So now, most of the people who migrate to the US, to UK, to all over Europe, Australia, Canada, we are everywhere. We are Hindus by religion, and the acts have extraterritorial application, which effectively means that whether I become a Canadian, American, a German, or a Britisher, my personal law goes with me on my back. So regardless of the domicile and nationality of the child or the parents, the application goes extraterritorially by having the implications. And this is why foreign marriage divorce decrees on irretrievable breakdown don't find recognition in India, because irretrievable breakdown is not a ground for divorce in India. So you have to get another divorce. And this is something which Mr. Jeremy Morley seriously needs to look into, of parallel divorces. The divorce decree in the US should be brought to India, imported in a nice package by Mr. Morley, and we should file a petition for divorce by mutual consent and convert the US decree into an Indian decree so that all is settled. The dowry case, the matrimonial violence case, the maintenance case, and the abduction cases are all dissolved. So this is the way to put an end to litigation. But where are the children? Worst sufferers. Now, culturally, we differ from the world. We believe we are still very biased towards the gender choice. Though I have now convinced the Supreme Court in 2 recent decisions that age and gender should take a back seat, and the enunciation has come. The Hindu Minority and Guardianship Act, which applies to all, says that the natural guardian of a child shall be the father, and after him the mother. After him doesn't mean he's dead. After him means when he's not involved. Ordinarily, the custody of a child less than 5 years of age shall be with the mother. Now, this has played a sort of a mechanical application for over, let us say, 50 years. So everybody says less than 5 years mother, more than 5 years father. In 2 recent decisions in Lahari Sakhamuri and Kiran Sethi versus Vasudeva, which is a decision in which in the High Court I was an amicus, and I had proposed to the court that the child should go back. So in these 2 cases, the court has said, no, it's not a decision-making process on the basis of age. Now, where have we got this jurisprudence? You see, let us understand, we do not have a statute to identify, to recognize child removal. I would not use the word abduction because even the convention doesn't use it. It's only in the title. It's wrongful removal or retention, which is actually finding application. So we do not recognize child removal by a parent as a wrong or an offense in civil terms or like the US in criminal terms. So it's quite a tough job for a court to adjudicate on a matter on this. And the worst situation is the Hindu Minority and Guardianship Act does not have any enabling law to take you to a court to get guardianship or custody. You have to fall back on the secular law, which thanks to the colonial British archives, we still retain. The Guardian and Wards Act of 1890. The Law Commission has said we should change it. Obviously, nothing has happened to it. So a parent who removes a child from the US or anywhere in the world comes in, rushes and says, goes to the guardian judge and says, give me an order of exclusive custody. Because that is what is provided for. You can choose to have exclusive custody. You cannot deprive the parent of his natural guardian status unless the guardian judge declares you unfit. So that is one part of the story. Now, the part which I brought in through persuasive arguments in the Delhi High Court in a matter which I convinced the court, this is Navtej Singh versus Jasmeet Kaur. These were two dentists who were US nationals who lived in the US for good 10 years, had a dental practice in Connecticut. The lady came to India for her brother's wedding. She overstayed. She didn't want to go back. She gave birth to a child. The bigger issue was, what is the nationality of the child? The child had to be an US national because both parents were US citizens. So the lady refused to go back. She went to the family court. I sought to enforce the US court decision in a writ of habeas corpus in the Delhi High Court. Ultimately, the matter landed up successfully in both the courts, that is the High Court, and it was taken to the Supreme Court of India. In the Supreme Court of India, I was able to enforce or bring in the mirror order jurisprudence, which is perhaps the best method in taking the children back. And the children have happily gone back to the US. So, Mr. Morley, I have added the mirror order jurisprudence as a feather to my cap. But the question still remains, which you will ask me, has India ever enforced a mirror order, which I have got from the US? That is a question I cannot answer because it has still not worked that way. But that apart, I'll come back to that later. So where have I brought in the change? For the attention of academics, Maya and Dr. Momo, I have brought in the UNCRC. We signed the UNCRC way back in 2000 and we acceded to the UNCRC on 11th of December 1992. So we have made a lot of changes in our domestic laws to give teeth to the UNCRC. Obviously, as Maya put it, or as Dr. Momo said it, the further steps were to get on to the 80 convention and the 96 convention. But we have not gone that way. We have signed the Adoption Convention of 1996, and we've got a very good system of inter-country adoptions going through because we have a central authority, the CARA, that is the Central Adoption Resource Authority, which works very well. And I have been advocating that if we were to sign the convention, that is the 1980 convention, we could have a central authority like the CARA for removal cases also, and we would have a passage going through. I was on the Justice Bindal committee as the only lawyer with 6 judges and 6 government officers, where we have brought out a bill and we have put this across. But that is in the pipeline. But the bigger question, the $1 million question is, what do we do till we actually sign the convention? Mr. William Duncan and Mr. Han Van Loon, the Dutch ambassador, myself, a few other judges, we almost got to it in 2007. But then Parliament terms were over, elections were announced, the government changed, and from 2007 to 2018, we gave in another report, but we are still struggling. We are still in the process of going on. We've got a very fast-track inter-country adoption process. We have got a surrogacy law booming, but in the matter of adoption, removals, I would not use the word adoptions, we have been rather slow, and I would be very candid to admit it. Mr. Morley has obviously given you figures. I don't disagree with him. Mr. Morley has been kind to me. He has not painted me black with a brush like China and Japan. Though I really didn't know they were that bad. Mikiko Tani would be very horrified to hear Mr. Morley's exposition of Japan. But that apart. So what did I do? Now, when I was at the committee, we heard a lot of left behind parents. We talked to a lot of parents overseas on video conferencing. We met a lot of people physically. and we actually recorded everything. And this that we heard both sides of the story. Obviously, there is no other way than to codify this first. Only then we can move forward. So that codification being far away, I found that the UNCRC, which has a lot of effective child-oriented rights, can actually lead to a child-centric jurisprudence in the judicial system. Now, so for me, the court process is the only method in which I can bring in some kind of decision-making process. Now, in our Supreme Court and our High Courts can expand their jurisdictions, like we did in matters of harassment at workplaces. The Supreme Court laid down guidelines, it resulted in a law. So there is judge-made law or ad hoc judicial decisions which lead to practice directions or guidelines which will acquire the force of law. It happened in one case in Surya Vadanan, but it got watered down later in two subsequent decisions because there is a flip-flop. But coming back to it, the gist of the UNCRC has got incorporated in the Juvenile Justice Care and Protection of Children Act 2015. And in that, there is a definition under Section 2, subsection 9 on the best interest of the child. Now, I'm going to read it to you because I have started reading this definition before every court in which there is a child removal and the child is to send back. And I tell the judge, you have to weigh your decision within the parameters of this definition. So let me read it to you. Best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. Now, by no standards can this be achieved by unilateral parenting, by single custody parent, or by keeping a child away from its home. Now, whatever decision-making process may have resulted from the Supreme Court in the terms of a precedent, from 1984 in Surinder Kaur's case up to 2021, Vasudha Sethi's case, we have consistently followed the rule that the jurisdiction of closest contact will determine the best interest of the child. This is a principle we have not diverted from. This is a principle we have not deflected from. It is just that you have to convince the court concerned that this child is American, Canadian, British. He or she has spent time there, her medical records are there, schooling is there. She is forcibly removed to India. India should not be projected as a haven for removed children, and the child should be sent back. There is a lot of thinking now which is accepting this definition. And in Lahari Sakhamuri's case, the Supreme Court said that the care and custody of a child less than 5 years of age cannot mean the love of the primary caregiver, i.e. the mother of a child less than 5 years of age, in view of the definition of the best interest of the child in Juvenile Justice Act. So the glass ceiling has been broken. The judge has effectively to see this is an American kid, this is a British child, these are European children, they have to go back from where they came. I am totally with Mr. Morley's reactions and observations that this takes time. This can be slow, this can be tardy, and this can take quite some time because after the matter goes to the High Court, it goes to the Supreme Court. But now the benches have started looking at these issues seriously. You must understand that in our country, where we have general practitioners, we do not have family law specialists in the family courts or the district courts or in the High Courts or in the Supreme Courts. There are no Mr. Morleys or Mr. Malhotra all over India. There are only 3 fellows or 4 fellows of the IAFL, and these are the only people who are specialists. We can count them on the fingers, but that's but all. So is the situation in the judiciary, like the family division in the RCJ London. We do not have any family division. Everybody deals with everything. There are no specialists. So this is also a sort of a stopgap, because you have to convince a judge that this child needs to go back. I don't have to go to the guardian judge and the guardian awards act to file a petition to prove that I am the custodian as a natural guardian. I have to be given a shortcut, because the extraordinary jurisdiction of the high courts, any high court in India or the Supreme Court of India, under the Constitution of India, is an extraordinary power as parents portray. And the child, effectively, they have in a short inquiry or a detailed inquiry to decide whether the child has to go back or has to remain. The sooner the decision, the quicker the going back. But again, as Marilyn pointed out, children being apart, children being in the country for too long, they don't want to see the mother. In a recent decision in the Supreme Court, after 3 years, the two daughters with the father said, we don't want to see our mother. So the court said, we can't send you back. So wishes of the child were predominant. There have also been cases where the one child is in England, one child is in India. They have been long apart. The parents split, and they hold one child in one country, and that's it. So the family is broken. So what I am trying to put together is that we are evolving a jurisprudence, but it is slow. Then the other problem is we have a Family Courts Act of 1984, under which every district or every small area in a state is supposed to have a family court where there is a population of 1 million plus. But the fact of the matter is that the family courts have not really been established. The family court needs to be established by a notification process of the government. It has to be set up and recognized by the government, and the judge has to be provided by the high court concerned, and then the family court becomes effective. So till the family court actually has a specialist family court judge, it takes time. Now we have started getting the apple cart together. I recently addressed a workshop of family court, 400 judges. It was a 2-day program of family court judges only in the northern territories of Punjab, Haryana, and Chandigarh, where we looked at different issues pertaining to children. I was a resource person. So we talked on these issues. So we are developing a jurisprudence. We are in a thought process of putting things together in a pipeline whereby we start looking at shared parenting. We start looking at joint custody. Bombay has done a very nice proposition. The family court in Mumbai, in Bandra, is a building which has 15 judges together. They have made it mandatory, first of all, for a shared parenting plan or a joint custody matter to be given to the court. And they have created the office of a child independent lawyer, which means the judge appoints an independent lawyer for the child who talks to the child, and the wishes of the child go through. So this is something which has come about in the past 2 years. I have really been pushing the signing of the convention by India. I face a lot of criticism from lawyers who are against the convention and who say that we will be sending our women to domestic violence once we send them back. If they go to the US, the children will be taken away, and this and that will happen. But you see, if we have to grow, if we have to prosper internationally, we have to fall into order in a system. We have to fall into place in an organized order. And I'm in agreement with all of you that if there are 100 nations on a convention, why can't we be there? We are already there in the matter of adoptions. We are already in the Hague network of judges. We are already in the discussions at the Hague, but why not into the convention? The bill is already there. We have to make a domestic law, so we can actually get into all this. It is a slow and evolving process, but then till that happens, I think the mirror order jurisprudence is going to work fine. But then there has been a fallback. there was the famous case of Parental. This was a case where the mother had kept the child in India for a long time. The Kenyan father pursued the matter in the family court. He won. It was appealed to the High Court. The mother lost. The father won. It went to Supreme Court, and the Supreme Court said, "We'll give a mirror order. You'll have to bring the child back whenever the mother wants to see her." He deposited a huge sum of money to stand by as guarantee, and everything was sorted out. Child went to Kenya. Once the child landed up in Kenya, he had a British passport, a Kenyan passport. The father says, "I'm not sending the child to India." So the mother went back to the Supreme Court. The Supreme Court directed him to appear before it. He did not appear. So the mirror order was recalled, and the matter has gone back to the family court for a fresh decision. So this is a backseat in this process. But what I would be interested to know is from Mr. Morley, he has said that the UCCJE, I'm aware of what it is and how good it is, but actually, how many Indian orders have actually resulted in return of children to India? Has it actually ever been done by him, or is there any particular case? Because I come up with a lot of questions, a lot of queries by persons who say, my child has been taken to the US. So I tell the parent very clearly, listen, there's nothing we can do because the jurisdiction of the Indian courts does not travel to America. But seeing to the jurisprudence of the UCCJEA, where a foreign state is recognized as a country, as a state of the US system, I think it's a good proposition if such a workable situation can come, because then that may evoke a respect for Indian orders, which may perhaps create a recognition for following the line likewise. So that is an issue which remains to be seen. But having been part of the discussions when Lord Justice Matthew Thorpe was there, I have attended 2 Wilton Park conferences where we have looked at the international network, Hague network of judges, and it's a brilliant proposition. Justice Andrew Moylan has done a brilliant job when he was there. Of course, the new judge is equally effective, but it's a very good initiative. We have to sit on the same table. We have to work out methods, and we have to evolve a world-class jurisprudence whereby children can move up and down, and India should no longer be on the red flag. Sorry, we are not sending children to India. I'm often cited as an expert, and this happened with us in a matter recently in a Canadian case where Mr. Morley gave evidence for the father. But when it was my turn to be cross-examined, the lawyer for the father turned around and said, Mr. Malhotra is not an expert in Canada. He may be talking of Indian law, but he's not a Canadian expert. Of course, the judge discounted it. It was shocking to me that I, as an IFL fellow, was facing this remark. But that apart, I tend to project before jurisdictions abroad that there are protective measures which can be put in place. And if a foreign court puts in those effective measures, we can try to enforce them in India, though the best interest of the child again comes in through the back door. But I think using the best interest of the child with those measures can serve the purpose. It's only good convincing power with the court and having a good lawyer wherever you are, which is what matters. So this is the long and short of India. I know we are a backseat. We are a huge jurisdiction. But let me tell you, for me, even the state of Chennai, that is Madras, Tamil Nadu, or the state of Kerala is a foreign jurisdiction. Because the language, the court practice, the system of how things are sorted out there is so different. Though we have a Family Courts Act of 1984, though we have the Guardian and Wards Act and the Hindu Minority and Guardianship Act, but the practical implementation and the process by which the court works, you cannot work unless you have a local lawyer. Though I travel, I do a matter in Goa, I do a matter in Ahmedabad, I do a matter in Hyderabad. The beauty of the Indian engagement system is that once you're a qualified lawyer, under the Advocates Act, you are licensed to practice. you can appear in any court of India, regardless of any jurisdictional rules, because the Bar Council license and entitles me to practice all over India. Now, this is something which most foreign lawyers don't know, but that is the freedom which I get to travel all over India. And I take the matter from the family court to the High Court to the Supreme Court throughout, without the necessity of having a QC or an expert like Mr. Morley, because I can sail in my own ship and I can blow my own trumpet. So,
thank you. We'll now just move on to the question and answer sessions as we're drawing to the end of this riveting discussion. I'll just pose 3 questions and I'll ask the speakers of this event to share their thoughts on this, and we'll try to keep this short. First being, there seems to be this resistance in domestic courts when it comes to looking at international law. Perhaps international law in that sense, as Mr. Morley said, he draws this very sharp and very precise distinction between international law as existing in these courts. So international law is active in domestic courts. It is used actively. But what perhaps would be most interesting to know is that the implementation and application of these principles to judges who perhaps are not aware, at least in the American case, of being specialized lawyers. Of course, having specialized lawyers and also perhaps judges has its pros and cons. So it'll be interesting to hear Mr. Morley's perspective on that perspective of specialist courts and also specialist lawyers. And I'll also try and look at this from the professor's perspective, because that's also important. Which aspect of this perhaps makes more sense to have specialized courts and also advocates in that perspective? I'm also quite interested to know if the perspective of having a special court or a special international tribunal, perhaps the arbitration example is too sharp or is too vivid. A sort of a special tribunal or a mediation center, an international mediation center, would make most sense, as both parties in these disputes want to resolve the dispute in comparison to other issues which are state to state, and prefer to, at least in some cases, prolong the litigation. I'll also be very interested to know from Professor Freeman that when rehabilitation takes place, how culturally appropriate or relevant is it? Does it become culturally specific? For instance, if the pair of the child belongs to a certain gender, certain race, certain region, then is it specific because that helps the rehabilitation further? And also, last question to the POEM project being that should it be oriented to judges? Because surely you cannot have programs educating parents, not something which they'll be quite inclined towards, or is education for the judges most important in those issues? I've posed these questions and these are open to anyone who wants to take a jab at them, and then within, let's say, 10 minutes, we can close. Thank you.
Yes, Jeremy, I think all the questions are for you.
So the US, our State Department requests other countries to have specialist judges in Hague Convention cases, and then our country violates that every day of the week because we don't have specialist judges ourselves. Another example of hypocrisy. We have 4,000 plus counties in America, each of which has a family court, at least one. And so there's 4,000 judges that can handle these cases, and Hague cases can go to federal courts or state courts. So there's another dozens and dozens and dozens of courts. We don't have specialization, but we do have family courts that handle these matters that are specialists in family law. But international cases are different. In my practice, the recommendation that I always make is that this particular case, which is in a particular city in Kentucky or a particular area of California, needs to be handled by a local lawyer in that area who knows the local court, who knows ideally the local judge. And yet this may be the first case of an international nature that this particular judge has ever handled. So you need somebody who is a specialist in international matters to hold the hand of the local family lawyer. The local family lawyer will be the one who will be in front of the judge much of the time, or maybe the entire time. But, and that's politically sensible in our system of so many different courts. You need to have local people. But but they need the help. They must always have the input of an international specialist. I think that's the only point that I'm going to make. Our judges are local, and so they don't know international law. Often it's the Hague case is the first case of that kind they've handled. I do want to respond to Mr. Malhotra's, Neil Malhotra's question about India and registering and enforcing Indian custody orders in the United States under the UCCJEA. The answer to that is I've never handled such a case. There's no reason why an Indian court order obtained when India was clearly the home state, when the defendant was given notice of the case and the opportunity to appear, why a court order in such a case would not be rubber stamped by an American court under the UCCJEA. I handled one recently from Malaysia. Actually, it involved people of Indian origin, but the family had moved to Malaysia and we enforced it successfully in Chicago. My client flew in from Malaysia, and it didn't take the 2 days that I indicated it could have taken. It took longer than that. It took probably a few weeks, but he was back with his child within those few weeks to Malaysia. And so it works. I have another case now where we are defending the registration of a foreign court order from a country in the Middle East. And we are claiming that as a matter of basic public policy, we should not enforce an order that was clearly based upon the age and gender and religion of the parents. And since the order in question expressly stated that custody would go to the Muslim parent and not to the Christian parent, that is offensive to an American court. And I'm expecting to win that case, but we're waiting for the decision, where we've now kind of added to I said there were only two defenses, whether, to registration, was it the home state and was due process complied with? Here we've added a public policy wrinkle and said it's fundamentally against public policy in this extreme and unusual case. I would expect that we would rubber stamp most Indian custody orders in this kind of situation.
Thank you, Professor.
Keep that in mind, and let's give it a shot when I get a matter next. Let's get America, India moving.
We'll have Professor Freeman next, please.
Yes, just to comment on the benefit of specialist courts, specialist judiciaries, and lawyers. I would say it's critical, completely critical. It's one of the things that we do have in the courts of the United Kingdom. We have a very specialized bar. We have a very specialized judiciary dealing with these cases. And why that isn't to sort of just wave flag and say, haven't we done well? Because we don't always do well, but in this particular case, I think we have done well with this. Without having that specialism, it can be like the blind leading the blind, and that's something that Professor Nigel Lowe said somewhere, and I'm copying the words because I think that's exactly what it can feel like. If the judge hasn't dealt with these cases before, if the counsel haven't dealt with these cases before, the significance and the impact of the case on the child concerned may not be understood, whether the child is going to be returned or not returned. Because when the child is returned, it is done, of course, in accordance with the ambitions and the aims of the Hague Convention, but it doesn't mean that there will be a case, a custody case in the state of habitual residence. It doesn't always happen. So the Hague Convention proceedings may be, and sometimes are, the only proceedings that will take place. And therefore, it's really, really important that the scope of the proceedings is properly understood, that the child has the opportunity to be heard, and that any exception to return that there may be is properly considered. And this, it's so contrary to the normal welfare principles which family courts and family advocates are used to working under, looking at the best interests of the child, that without having that degree of specialism in convention cases, in abduction convention cases, a lot of the issues may not happen, may not be investigated, may not be explored in the way that they should be. Now, that is not to say in any way that to undermine the efficacy of the convention, which we mustn't do, and it must be safeguarded and it must be upheld. But within the convention, there are possibilities, and they are there for good reason, and that they must be honoured in the same way as the aims of the convention. So that I would just say, yes, my vote goes to specialism. And you asked a question about reconciliation and whether that was culturally specific. Well, of course, the two parties, the let's call it the abducting parent and the left behind parent, may very well be and often are of the same background and the same culture. So it isn't always that you have two parents who are of different cultures. That it doesn't always have that profile. And when a child is returned, the child is returned to the state of habitual resident. It's not necessarily to the left behind parent. So culture doesn't really come into that. It's much more defined than that. It's a return to the state of habitual residence, and whatever that is whatever it is. So I don't think it's a cultural issue at all. Okay, thank you.
I want to interject here. Sorry for the interruption. Now, I have been hearing a viewpoint that the 1980 convention has failed to serve its purpose, and that there is criticism, and that it should be replaced by a more effective convention. And what is your take on this? I think Maya may be able to add to whatever you have to say, but since you are the key person with hands-on sitting in the heart of the world, London, so you would have the academic take on this.
So, Anil, you're asking me whether I'm a great supporter of the 1988 convention. I think it's I think it it's now 40-something years old. And I think that it's a question of interpretation, and I think that we learn as we go along, and things change, and I think it is a dynamic convention. So I'm a great supporter. I don't advocate a change in the convention at all. I just think that we need to be conscious and aware and learn as we go along, and be prepared to interpret in the light of that knowledge. So, I mean, for example, in the UK, we now have a great emphasis on hearing the child, in a much broader understanding of why that's required, and a much greater willingness to do that. So and that's again something that I would support, that learning as we go along, but supporting the convention at the same time.
Professor, the floor is yours. Then we'll have Dr. Momo, and perhaps then we can close. Thank you.
I'm grateful. I wanted to add to the chorus in terms of the United Kingdom, certainly England and Wales, which is my experience, as to having a jurisdiction that is concentrated. In fact, my most recent case, the case I just did last month, involved the removal of a child from Malta to the United Kingdom, but a child that was in foster care. But it also raised the issue of asylum, so immigration, in that the child's mother had claimed asylum in the UK upon arrival. Some may be familiar with the recent G&G case in the Supreme Court that dealt with, the interplay between immigration and asylum. I think it was a South African case. But the point I make is this, that I was before Mrs. Justice Knowles, who was explaining to us that in fact she was one of the very few judges, so within that specialised panel of judges who is tasked with dealing with cases that engages immigration and international child abduction. So I think that it's right, and I would echo that we're definitely on the ball and trying to, keep learning and keep evolving in the way we interpret and apply the Hague Convention. In that case, the child was 8 years old, and there was a CAFCAS report in relation to her wishes and feelings. And if it assists at all, I also think that the Hague Convention, I think to scrap it or to remove it would be a lacuna, a void that simply cannot be filled. Just to deal with the point that you asked about the POAM project, in fact, the aim of the project, is certainly the guide to the best practice guide that is the main output in that project or deliverable, is to assist child abduction professionals, including judges, legal practitioners, NGO representatives, and central authorities in the way they deal or they approach cases where allegations of domestic violence have been raised, so that the resources and the events that took place during the course of the project, including local workshops across various jurisdictions. In the UK, we had Supreme Court judge from Scotland, we had of course, Lord Justice Moyland was present at one of our workshops. We had Sir Matthew Thorpe, etc., as well as lawyers and of course, members of relevant authorities. So there are training materials, and there's the best practice guide, and there's a journal article, etc. And there's a book with, of course, Professor Freeman, who's contributed to that. Thank you, which is coming out. So all of which to educate the facilitators, the interpreters of the Hague Convention. Thank you.
Thank you. Professor Maya, the floor is yours.
Yes, just to echo what colleagues have said about the great merit and desirability of concentration of jurisdiction for 1980 Convention cases, and indeed other international child protection cases, for example, under the 1996 Convention. So this has been a recommended good practice by the Hague Conference Secretariat for many, many years, and at special commissions, there's been a lot of discussion to review these conventions. This is absolutely highly recommended for all of the reasons that were described. It's so tricky for a judge, hearing only one 1980 Convention case in his or her whole career. It's very, very challenging given all of the complexities, sensitivities, and intricacies of these cases, not to mention, of course, the expedition requirements is supposed to be within 6 weeks. So there's the UK example is one very good example. Germany, of course, also here in the Netherlands, the Dutch have very effectively concentrated jurisdiction, and they also even have kind of a set procedure which it folds in mediation and mediation process if appropriate. In some instances of severe domestic violence, that isn't appropriate, but if there is this concentrated focused jurisdiction, there is indeed this expertise and skill built up, a knowledge of jurisprudence of other states, and also knowledge of the good practices that come out of these special commissions at the international level to review the conventions. So yes, highly, highly desirable, recommended. But of course, in default, education, judicial education, resources, as Anil was talking about, this dialogue that's going on, and sort of trying to build the knowledge and resources about how these conventions, their key principles, and how they can work best in practice, and also the resources that are available there, all the guides to good practice, the International Hague Network of Judges, which can also be informational. Judges can help judges within a certain jurisdiction. For example, within the US, that often happens. The network judges really try to help and support with information, the judges hearing cases. And just, in terms of the question about, should there be a new iteration of this convention at some point, or a different convention? I mean, national law, international law does evolve, and it should progress and evolve over time. There was, a proposal raised a number of years ago at the Hague Conference among states parties, potentially, with this proposal, should we amend or think about a protocol? And that did not get the support of the vast majority of contracting states to the convention. So there's very little appetite among contracting states because they are indeed so invested in trying to make this system work. And as was said, there has to be an evolution in skill and expertise and ability to really implement and ensure that the convention is operating in the optimal way, really in the best interests of children and their families. So there's so much we can do within this convention framework. And there's so much knowledge, but just it needs constant efforts.
And as a Society of International Law, we take this effort quite seriously. And with that, I thank all our speakers for taking out time to do this on a very busy day. And we're so deeply honored and obliged for everyone who's here. We're also thankful to all participants who've taken the time to watch this on the YouTube channel of our university. I once again thank all our speakers for doing this. Thank you so much. And this lecture is over. Thank you.
Marilyn, Jeremy, Dr. Momo, please send me your addresses so that I can send you our latest signed copy of the book.
Thanks, Anil.
Thank you all. Nice to see everyone.
Thank you. Take care, everyone. Bye.
Bye.
Marilyn,
Thanks very much. Bye-bye.
Marilyn, gone.